The morning sunlight filtered through the tall windows of Courtroom 302, casting long rectangles of light across the polished wooden floor. Tanya Washington adjusted her navy blue blazer and took a deep breath as she prepared to present her case. At 34 years old, she had become used to being underestimated in the legal profession, but today's case was too important to let personal feelings interfere. Judge Robert Harrington entered the courtroom, and everyone rose to their feet. His reputation preceded him. 20 years on the bench had earned him respect, but also a reputation for being tough on attorneys he deemed unprepared. He had silver hair, thick eyebrows, and eyes that seemed to evaluate everything with skepticism. Case number 47,293, Blackwell versus Ridgemont Properties, announced the clerk. Tanya glanced at her client, Mrs. Elaine Blackwell, a tired-looking woman in her 40s who sat nervously clutching her purse. As a single mother of two working double shifts at the hospital, she was facing eviction for housing violations that were clearly the landlord's responsibility to fix. Your Honor, Tanya began, her voice steady and clear, my client has been served an eviction notice based on housing code violations that she has repeatedly requested be repaired. According to Section 8.14 of the City Housing Code, these repairs are the legal responsibility of the property owner, not the tenant. Judge Harrington's eyebrows rose slightly as he looked at Tanya over his reading glasses. And you are? He asked, though her name was clearly printed on the documents before him. Tanya Washington, representing Mrs. Blackwell, Your Honor. The opposing counsel, a man in an expensive suit who represented Ridgemont Properties, smirked slightly. Tanya continued, I'd like to present documentation showing that Mrs. Blackwell made 6 separate formal requests for repairs over the past 8 months. As she began to outline the specifics of the case, Judge Harrington let out a short laugh that echoed through the courtroom. Ms. Washington, he interrupted, surely you're not suggesting that Section 8.14 applies in this specific instance. That's a rather creative interpretation of the statute. The way he said creative made it clear he thought her argument was absurd. A few people in the courtroom chuckled along with him. The opposing counsel's smirk grew wider. Tanya felt her heart beat faster, but her expression remained calm. She had faced this kind of dismissal many times before. She noticed Mrs. Blackwell shrink in her seat, likely seeing her hopes of keeping her home fade away. Your Honor, if I may continue, Tanya said evenly, I believe the statute is quite clear on this matter. Additionally, I have precedent from John versus Landmark Holdings where the court ruled that structural issues affecting habitability fall squarely on the property owner. Judge Harrington waved his hand dismissively. Ms. Washington, I'm familiar with that case, and the circumstances were quite different. With all due respect, Your Honor, Tanya replied, pulling out another document from her well-organized folder. I'd like to cite another relevant case that may clarify the application of Section 8.14. The judge sighed with obvious impatience but gestured for her to continue. Tanya stood a little straighter. This was the moment she had prepared for. She knew exactly what she was doing, and despite the judge's laughter and the opposing counsel's confidence, she had an ace up her sleeve. The courtroom might see her as an easy target now, but that perception was about to change dramatically. The case I'd like to discuss, she said calmly, is Harrington versus City Council, 1986. The judge's expression changed instantly, his eyes narrowing with sudden interest. The courtroom fell silent. Judge Harrington's face transformed from dismissive amusement to focused attention. He leaned forward slightly, his reading glasses sliding down his nose. Harrington versus City Council, he repeated, his voice quieter than before. Yes, Your Honor, Tanya confirmed, maintaining her composure. A case from 1986 where the plaintiff's attorney, yourself, before you joined the bench, successfully argued that property owners cannot transfer responsibility for structural repairs to tenants, even when lease agreements state otherwise. The opposing counsel, Mr. Davidson, shifted uncomfortably in his seat. He hadn't prepared for this turn of events. Judge Harrington's past as a tenant rights attorney wasn't widely discussed these days. Most lawyers in the room were too young to remember his earlier career. That was a different time, Ms. Washington, Judge Harrington said carefully, and different circumstances. The circumstances were remarkably similar, Your Honor, Tanya replied, opening a worn legal text marked with colored tabs. The plaintiff in that case was also facing eviction due to code violations caused by neglected repairs. Your argument then was that, and I quote, to allow landlords to profit from their own negligence by punishing tenants for conditions beyond their control is contrary to both the letter and spirit of housing law. A murmur spread through the courtroom. Mrs. Blackwell looked at Tanya with newfound hope in her eyes. Judge Harrington cleared his throat. I'm impressed with your research, Ms. Washington, but legal interpretations evolve over time. Indeed they do, Your Honor. Tanya agreed. She pulled out another document, which is why I've also brought the ruling from Mendez versus Highland Properties from just last year, which cited your case as precedent and reinforced the same principle. Mr. Davidson stood up quickly. Your Honor, this is irrelevant to our current case. The violations in Mrs. Blackwell's apartment are clearly stated in her lease as her responsibility. Tanya was prepared for this argument too. She had spent nights studying Mrs. Blackwell's lease, the relevant housing codes, and the history of Ridgemont Properties. If I may, Your Honor, she said, pulling out the lease agreement. Section 12 of Mrs. Blackwell's lease does mention tenant responsibilities, but Section 17 clearly states that all structural and safety-related repairs remain the landlord's obligation. The violations in question, water damage from a leaking roof, electrical issues in the bathroom, and a broken heating system, all fall under structural and safety concerns. Judge Harrington took the lease she offered and examined it carefully. The courtroom remained silent as he read. Tanya continued while he reviewed the document. Furthermore, I have copies of all 6 repair requests Mrs. Blackwell submitted, each one acknowledged by the building manager but never addressed. The first request was made 8 months ago, long before any code violations were cited. Mrs. Blackwell nodded, her hands still clutching her purse but with less anxiety now. Judge Harrington looked up from the lease. His initial laughter seemed far away now. He was looking at Tanya differently, with the respect given to a worthy legal opponent. Mr. Davidson, the judge turned to the opposing counsel. Does Ridgemont Properties have documentation showing why these repair requests were ignored for 8 months? Davidson hesitated. Your Honor, we have a large portfolio of properties and maintenance requests are handled according to priority. That wasn't my question. Judge Harrington interrupted sharply. Do you have specific documentation regarding Mrs. Blackwell's requests? I would need to consult with my client, Toe. I see. Judge Harrington cut him off again. He turned back to Tanya. Ms. Washington, you mentioned you have more evidence to present. Tanya nodded confidently. Yes, Your Honor, and I believe it will demonstrate a troubling pattern of neglect that goes well beyond Mrs. Blackwell's individual case. The people watching from the gallery leaned forward. The court reporter's fingers paused briefly over her machine. Judge Harrington's eyes narrowed with interest. Proceed, he said. Tanya reached into her briefcase and pulled out a thick folder marked with green tabs. Her movements were deliberate, unhurried. She could feel the eyes of everyone in the courtroom following her actions. Your Honor, I'd like to present evidence showing that Ridgemont Properties has a pattern of neglecting repairs in specific buildings while promptly addressing issues in others. She walked forward and handed copies to the court clerk for distribution. Mr. Davidson jumped to his feet. Objection, Your Honor. This goes beyond the scope of today's hearing. We're here to discuss Mrs. Blackwell's specific lease violations, not my client's broader business practices. Your Honor, this evidence shows that Ridgemont Properties responds to maintenance requests within 48 hours in buildings located in Westfield and Oakwood neighborhoods, but takes an average of 47 days to address similar requests in Southside properties like Mrs. Blackwell's building. She paused, letting the information sink in. The courtroom remained silent. The difference between these neighborhoods is significant. Westfield and Oakwood are predominantly white, while Southside is 83% Black and Hispanic. This demonstrates that the neglect of Mrs. Blackwell's repair requests is not due to oversight or lack of resources, but part of a discriminatory practice. Mr. Davidson's face flushed red. This is outrageous. My client categorically denies any discriminatory practices. Judge Harrington raised his hand to silence the attorney. I'll allow this evidence, Mr. Davidson. It speaks to pattern and intent. He turned to Tanya. Continue, Ms. Washington. Tanya nodded and pulled out another document. I've also brought the inspection records for all Ridgemont properties over the past 3 years. You'll notice that while violations exist across their properties, eviction proceedings based on these violations have only been initiated in Southside buildings. Mrs. Blackwell gasped softly beside her. This was clearly new information to her as well. Furthermore, Tanya continued, I have statements from 7 other tenants in Mrs. Blackwell's building who experienced similar issues with repair requests being ignored, followed by threats of eviction when code violations were eventually discovered. Judge Harrington's expression had transformed completely from his earlier dismissive attitude. He was studying the documents with deep concentration, occasionally glancing up at Tanya with what appeared to be grudging respect. Mr. Davidson conferred frantically with his assistant, flipping through papers. Your Honor, he finally said, even if there were delays in addressing some repair requests, the fact remains that Mrs. Blackwell's apartment currently has code violations that must be addressed. Tanya was prepared for this argument too. Indeed, Your Honor, and Mrs. Blackwell is eager to have her apartment brought up to code. The question is not whether repairs are needed. They certainly are. But who bears the responsibility for making them, and whether eviction is an appropriate response to conditions caused by the landlord's neglect. She pulled out one final document. I drafted a proposed order that would require Ridgemont Properties to make all necessary repairs within 14 days, waive Mrs. Blackwell's rent during this period, and dismiss the eviction proceedings. The confidence in her voice made it clear she wasn't merely hoping for this outcome. She expected it based on the strength of her case. Judge Harrington took the proposed order and read it carefully. The courtroom remained silent, the tension almost tangible. Mr. Davidson looked increasingly worried, whispering urgently to his assistant. Ms. Washington, Judge Harrington finally said, setting down the document, you've presented a compelling case so far. He turned to Mr. Davidson. Counsel, I'm particularly interested in hearing your response to the maintenance records showing these disparities in response times between neighborhoods. Mr. Davidson stood, adjusting his tie nervously. Your Honor, we would need time to review these allegations and prepare a proper response. We request a continuance to. Mr. Davidson, the judge interrupted. Are you telling me you came to court today unprepared to discuss your client's own maintenance records? The opposing counsel's face reddened further. No, Your Honor, but these specific comparisons are new information that. Very well, Judge Harrington cut him off. We'll take a short recess, 15 minutes. I suggest you use that time wisely, Counselor. As the judge left the bench, Mrs. Blackwell turned to Tanya with tears in her eyes. I didn't know others were going through this too, she whispered. Tanya squeezed her hand reassuringly. That's exactly what they count on, Mrs. Blackwell. Isolated individuals are easier to intimidate than a united community. The 15-minute recess stretched to 20 as Mr. Davidson frantically made phone calls in the hallway. When everyone returned to the courtroom, Judge Harrington's demeanor had changed completely from his earlier dismissive attitude. He looked at both attorneys with keen attention, hands folded in front of him. Mr. Davidson, are you prepared to respond to Ms. Washington's evidence? The judge asked. The opposing counsel stood, looking considerably less confident than he had at the start of the hearing. Your Honor, after consulting with my client, Ridgemont Properties is willing to address the maintenance issues in Mrs. Blackwell's apartment as a gesture of goodwill, without admitting any wrongdoing. Tanya remained seated, her expression calm but determined. She knew this tactic well, the offer to fix just one tenant's problems while maintaining the system that created them. However, Mr. Davidson continued, we maintain that these issues do not represent a pattern of discrimination as Ms. Washington suggests. The response time differences between neighborhoods can be explained by various factors unrelated to the demographics of the residents. Judge Harrington raised an eyebrow, such as? Davidson hesitated. Different building ages, varying complexity of repairs, staffing allocations. Do you have documentation showing these factors were the actual cause of the delays? The judge interrupted. We would need time to compile such information, Your Honor. Judge Harrington nodded slowly. Ms. Washington, your response. Tanya rose smoothly to her feet. Your Honor, if I may direct your attention to page 17 of the maintenance records. You'll see that identical issues, such as leaking roofs and heating failures, were addressed within 48 hours in Westfield properties but remained unresolved for weeks or months in Southside buildings, including Mrs. Blackwell's. These are buildings of similar age with similar staffing levels. She waited as Judge Harrington and Mr. Davidson both turned to the relevant page. Furthermore, Tanya continued, on page 23, there's an internal email from Ridgemont's maintenance director instructing staff to prioritize higher-value properties, which clearly refers to those in Westfield and Oakwood based on the property ID numbers listed. The spectators in the courtroom murmured. Judge Harrington tapped his gavel lightly for silence. Mr. Davidson, would you care to explain this email? The judge asked. Davidson's face paled slightly. He hadn't expected such specific evidence. Your Honor, business decisions about property maintenance must consider return on investment. This is simply sound business practice, not discrimination. Tanya saw her opening and took it. Your Honor, I'd like to refer back to Harrington versus City Council, 1986, where you yourself argued that housing is not merely a business transaction, but a basic human need protected by law. You specifically stated that economic calculations cannot supersede the right to safe, habitable housing. A slight smile played at the corner of Judge Harrington's mouth for just a moment. Tanya had done her homework thoroughly. Mrs. Blackwell sat up straighter in her chair, watching the exchange with growing hope. Other tenants from her building who had gathered in the gallery leaned forward, seeing for the first time that their individual struggles might be part of a larger issue that could actually be addressed. Judge Harrington turned to Mr. Davidson. Counsel, I'm not seeing the substantive response to the evidence Ms. Washington has presented. Your Honor, we request more time to prepare a detailed. No. Judge Harrington cut him off firmly. This hearing has been scheduled for weeks. If Ridgemont Properties wasn't prepared to address these issues today, that's not the court's problem. He turned to Tanya. Ms. Washington, you mentioned having tenant statements. Yes, Your Honor. Tanya pulled out 7 signed affidavits. These are from other residents in Mrs. Blackwell's building, all describing similar experiences with ignored repair requests followed by eviction threats when the problems worsened. As the clerk distributed copies of the statements, Mr. Davidson conferred urgently with someone on his team who had just entered the courtroom with a worried expression. The whispered conversation grew increasingly tense. Finally, Davidson turned back to the judge. Your Honor, in light of this situation, my client would like to propose a settlement. We're willing to make all necessary repairs to Mrs. Blackwell's apartment and dismiss the eviction proceeding. Tanya shook her head slightly. And the other tenants, Your Honor. Judge Harrington nodded, understanding her point. Mr. Davidson, Ms. Washington has presented evidence suggesting a systemic issue, not just an individual case. How does your client propose to address that? Mr. Davidson's expression tightened as he realized the case had grown far beyond what he had prepared for. He shuffled through his papers, desperately searching for anything that might help his position. Your Honor, my client is willing to review the maintenance procedures for all properties. We maintain that this hearing should be limited to Mrs. Blackwell's specific situation, he said, his voice lacking its earlier confidence. Judge Harrington leaned back in his chair, studying both attorneys. The courtroom remained silent, everyone sensing they were witnessing something important unfold. Ms. Washington, the judge said finally, what remedy are you seeking here today? Tanya stood tall, her posture perfect. This was the moment she had been building toward. Your Honor, we asked for 3 things. First, immediate dismissal of the eviction proceeding against Mrs. Blackwell. Second, an order requiring Ridgemont Properties to make all necessary repairs to her apartment within 14 days. And third, she paused, looking directly at Judge Harrington. Third, we asked the court to certify a class action on behalf of all Southside tenants of Ridgemont Properties who have experienced similar discriminatory maintenance practices. Mr. Davidson jumped to his feet. Objection. That goes far beyond the scope of today's hearing. This is about one tenant, one apartment, one eviction proceeding. Judge Harrington raised his hand. Mr. Davidson, I'm well aware of what was originally scheduled for today. However, Ms. Washington has presented compelling evidence of a potentially discriminatory pattern that cannot be ignored. He turned to Tanya. A class action certification would require additional proceedings and evidence. However, I am deeply concerned by what I've seen today. The judge picked up the maintenance records again, flipping through them slowly. These response time disparities are troubling, to say the least. Mrs. Blackwell whispered to Tanya, "What does this mean?" "It means we're being heard," Tanya whispered back, giving her client's hand a reassuring squeeze. Judge Harrington closed the folder and looked up. "Here's what I'm prepared to do today. First, the eviction proceeding against Mrs. Blackwell is dismissed." He raised his hand as Mr. Davidson began to protest. "Let me finish, counselor." The courtroom fell silent again. Second, Richmond Properties is ordered to complete all necessary repairs to Mrs. Blackwell's apartment within 10 days, not 14 as requested, with daily inspections by the Housing Authority to ensure compliance. Tanya nodded in approval. Third, the judge continued, "I'm ordering Richmond to provide complete maintenance records for all properties for the past 5 years within 30 days. The court will review these records to determine if a pattern of discrimination exists." Mr. Davidson looked stunned. "Your Honor, that's thousands of records." "Then I suggest you begin compiling them immediately," Judge Harrington interrupted firmly. "If your client has nothing to hide, this should pose no problem." He turned back to Tanya. "Ms. Washington, I'm not granting class action certification today, but I am scheduling a follow-up hearing in 45 days to review the complete records and determine if such certification is warranted." Tanya nodded respectfully. "Thank you, Your Honor." The people sitting in the gallery, many of them Southside residents, broke into whispers of excitement. Judge Harrington tapped his gavel lightly to restore order. "One more thing," the judge added, looking directly at Mr. Davidson. "During this 45-day period, Richmond Properties is prohibited from initiating any new eviction proceedings against tenants in Southside buildings based on code violations without first demonstrating that those violations occurred despite timely maintenance response." Mr. Davidson's face reddened with frustration. "Your Honor, that effectively prevents my client from exercising their legal rights as property owners for a month and a half." Judge Harrington's expression hardened. "What it prevents, counselor, is potential retaliation against tenants while this matter is being investigated." Mrs. Blackwell's eyes filled with tears of relief. Other tenants in the gallery exchanged hopeful glances. For many of them, this was the first time they had seen the legal system work in their favor. Tanya remained outwardly calm, but inside, she felt a surge of satisfaction. The judge who had laughed at her just hours earlier was now ruling in her favor on almost every point. The courtroom buzzed with excitement as Judge Harrington finished announcing his ruling. Mrs. Blackwell dabbed at her eyes with a tissue, while Mr. Davidson huddled with his assistant, their faces grim. Tanya began organizing her documents, maintaining her professional composure despite the victory. The judge tapped his gavel once more. "We'll recess until—" "Your Honor," Mr. Davidson interrupted, standing abruptly. "Before we conclude, I just received information that I believe is relevant to these proceedings." Judge Harrington frowned at the interruption but gestured for him to continue. "It has come to our attention," Davidson said, his voice regaining some confidence, "that Ms. Washington has a personal connection to this case that she failed to disclose to the court." The murmuring in the courtroom stopped. All eyes turned to Tanya, who looked genuinely puzzled. "Ms. Washington grew up in Southside," Davidson continued, "in the very building where Mrs. Blackwell now resides. Her mother still lives 3 floors below Mrs. Blackwell's apartment. This represents a clear conflict of interest that should have been disclosed." Judge Harrington turned to Tanya with raised eyebrows. "Ms. Washington?" Tanya stood slowly, her mind racing. She hadn't expected this line of attack. "Your Honor, I did grow up in that building, and my mother does still live there. I didn't disclose this because it doesn't constitute a legal conflict of interest as defined by the Bar Association's ethical guidelines." Davidson pressed his advantage. "Your Honor, Ms. Washington clearly has a personal vendetta against Richmond Properties. This entire case is being driven by her personal history, not the legal merits." Tanya felt a flash of anger but kept her voice steady. "Your Honor, my personal history gives me knowledge of the community, not a conflict of interest. I have no financial stake in the outcome, which is the standard for such conflicts." Judge Harrington considered this for a moment. "Mr. Davidson, while this information is interesting, I fail to see how it constitutes a legal conflict of interest." An attorney's background and community connections don't disqualify them from representing clients from that community. Davidson wasn't giving up. But, Your Honor, she's effectively representing her own mother's interests without disclosing it. My mother is not a party to this case, Your Honor, Tanya responded. Mrs. Blackwell is my client. If the court's ruling happens to benefit other tenants in the building, including my mother, that's incidental to the legal issues at hand. The judge nodded. I agree, Ms. Washington. However, in the interest of full transparency, is there anything else about your connection to this case that you think the court should know? Tanya took a deep breath. This was a crucial moment. She could simply say no and move on, but she made a different choice. Yes, Your Honor. There is something else. The courtroom grew completely silent. When I was 12 years old, my family was evicted from that same building because of code violations that were the landlord's responsibility, though the building was owned by a different company at that time. We spent 3 months in a shelter before finding new housing. She looked directly at Judge Harrington. That experience is what inspired me to become a housing attorney. I believe everyone deserves safe, clean housing, and that the law should protect tenants from predatory practices. But that personal history doesn't affect my ability to represent my client according to the facts and the law. Judge Harrington studied her for a long moment. Thank you for your candor, Ms. Washington. He turned to Davidson. Counselor, an attorney's personal experiences that lead them to their field of practice do not constitute a conflict of interest. If anything, they provide valuable insight. Your objection is overruled. Davidson's shoulders slumped slightly. His last-minute attempt to undermine Tanya had backfired. However, the judge continued, turning back to Tanya, in future proceedings related to this matter, I would expect full disclosure of any personal connections, even those that don't technically constitute legal conflicts. Transparency serves everyone's interests. Yes, Your Honor, Tanya agreed, relieved that her case was still intact. Judge Harrington nodded. We'll recess until the follow-up hearing in 45 days. Ms. Washington, I'll expect a written brief outlining the legal basis for class certification by next Friday. As the judge left the bench, the gallery erupted in excited conversation. Mrs. Blackwell hugged Tanya tightly. You never told me you grew up in our building, she whispered. Tanya smiled. Some things you don't talk about until the right moment comes. The 45 days following the hearing passed in a whirlwind of activity for Tanya. Her small law office transformed into a buzzing center of community action as tenants from across Southside came forward with their stories. What had begun as Mrs. Blackwell's individual eviction case was evolving into something much larger. Each evening, after her regular caseload, Tanya sorted through maintenance records, lease agreements, and tenant statements. Her dining room table disappeared under stacks of documents as she built her case for class certification. Sometimes she worked until dawn, fueled by coffee and determination. On the 40th day, as Tanya reviewed the maintenance records Richmond Properties had been ordered to provide, she discovered something unexpected. She immediately called her paralegal, Marcus. Look at the Westfield repair records from last year compared to this year, she said when he arrived at her apartment, pointing to 2 spreadsheets side by side on her laptop. Marcus studied them, his eyes widening. The response times have doubled this year. They're getting slower. Exactly, Tanya said. And look at Southside's records for the same period. Marcus leaned closer. They're improving? Response times are down by almost 30%. Tanya nodded, a small smile forming. Richmond is trying to cover their tracks. They're deliberately slowing down repairs in white neighborhoods while speeding them up in black ones, just enough to blur the statistical differences before our follow-up hearing. That's actually good for us, right? Marcus asked. It proves they could have been responding faster to Southside requests all along. Better than that, Tanya said, pulling up another document. It proves they're manipulating their maintenance response times based on race. They're essentially admitting guilt by trying to hide it. The morning of the follow-up hearing arrived with a sense of anticipation. The courtroom was packed, with journalists occupying the back row. Word had spread about the case and its potential implications for housing discrimination lawsuits throughout the city. Judge Harrington entered, his face serious as he surveyed the crowded room. Mr. Davidson sat at the defense table with 3 additional attorneys beside him, a sign that Richmond Properties recognized the growing threat. Before we begin, Judge Harrington said after calling the court to order, "I want to acknowledge that this case has expanded significantly from its original scope. What began as a single eviction defense has raised important questions about housing discrimination that this court takes very seriously." He turned to Mr. Davidson. "Counsel, have you complied with the court's order to provide complete maintenance records?" Davidson stood. "Yes, Your Honor. We've submitted over 4,000 pages of records covering all Ridgement properties for the past 5 years." "And have you completed the repairs to Mrs. Blackwell's apartment as ordered?" "Yes, Your Honor. All repairs were completed within the 10-day window and verified by housing authority inspectors." Judge Harrington nodded and turned to Tanya. "Ms. Washington, are you prepared to proceed with your motion for class certification?" Tanya rose, wearing the same navy blazer she'd worn at the first hearing, but carrying herself with even greater confidence. "Yes, Your Honor. And I've discovered new evidence in the records provided by Ridgement that strengthens our case considerably." She approached the bench with copies of her analysis. "These charts show that after our initial hearing, Ridgement deliberately manipulated their maintenance response times, slowing down repairs in predominantly white neighborhoods while speeding them up in black neighborhoods, in an obvious attempt to obscure the racial disparities before today's hearing." Gasps and whispers filled the courtroom as the judge examined the charts. Mr. Davidson jumped to his feet. "Objection, Your Honor. This is a baseless accusation. The improvement in response times simply shows my client's good faith effort to address the court's concerns." Judge Harrington studied the documents carefully, and the simultaneously increasing delays in other neighborhoods. "How do you explain that, Counselor?" Davidson faltered. "There could be many factors: staffing issues, more complex repairs." "The same explanations you offered last time," the judge noted dryly. "Yet somehow these factors only affect certain neighborhoods." He looked up at Tanya with new respect in his eyes. "Ms. Washington, your analysis is compelling. This appears to be a deliberate attempt to manipulate evidence before the court." Tanya nodded. "Yes, Your Honor, and it demonstrates exactly why class certification is necessary. Individual tenants cannot fight this systemic discrimination alone." 6 months after the initial hearing where Judge Harrington had laughed at Tanya Washington, the same courtroom was filled to capacity. News cameras waited outside, and reporters scribbled notes in the back row. The case of Blackwell v. Ridgement Properties had become headline news across the city. Judge Harrington entered and took his seat at the bench, his demeanor entirely different from that first day. He nodded respectfully toward Tanya before calling the court to order. "Today we conclude what began as a simple eviction case but evolved into one of the most significant housing discrimination cases this court has seen in decades," he began. "I have reviewed all evidence, testimony, and legal arguments presented by both sides." Tanya sat beside Mrs. Blackwell, who was now joined by 27 other plaintiffs from various Ridgement properties across Southside. The class action certification had been granted 3 months earlier, despite aggressive opposition from Ridgement's expanded legal team. After careful consideration, Judge Harrington continued, "This court finds that Ridgement Properties engaged in a pattern of discriminatory maintenance practices in violation of the Fair Housing Act." A collective gasp swept through the room. Mr. Davidson and his team remained stone-faced. "The evidence clearly shows that Ridgement systematically delayed repairs in properties located in predominantly black neighborhoods while providing prompt service to buildings in predominantly white areas." Judge Harrington looked directly at the Ridgement executives sitting behind their attorneys. Further, the attempt to manipulate response times after this case began represents a troubling effort to deceive this court. The judge detailed his ruling. Ridgement Properties was ordered to pay $3.2 million in damages to current and former tenants of their Southside buildings, establish a new maintenance system with strict response time requirements that would be monitored by a court-appointed observer for 5 years, and implement comprehensive anti-discrimination training for all staff. Additionally, Judge Harrington concluded, Ridgement Properties is prohibited from evicting any tenant based on code violations without first demonstrating that those violations were not caused by the company's own maintenance failures. As the judge finished reading his decision, Mrs. Blackwell squeezed Tanya's hand tightly. Tears streamed down her face. Around them, other tenants embraced each other in relief and joy. After the court adjourned, A crowd gathered around Tanya in the hallway. Reporters called out questions while tenants wanted to express their gratitude. Through the chaos, she noticed Judge Harrington motioning for her to approach. "Ms. Washington," he said quietly when they stood apart from the crowd, "I owe you an apology." Tanya looked surprised. "That first day," he continued, "I made assumptions about you and your case that were unworthy of this court. I failed to give you the respect you deserved as an attorney." "Thank you, Your Honor," Tanya replied, "but what matters most is the outcome for the tenants." The judge nodded. "You've done more than win a case, Ms. Washington. You've reminded this court of principles I once fought for myself but had perhaps lost sight of over the years." As Judge Harrington walked away, Tanya's mother approached, her eyes shining with pride. "Remember when you told me you wanted to be a lawyer after we got evicted?" her mother asked, embracing her. "I was worried it would be too hard for you, that the system wouldn't let someone like us win." Tanya smiled. "It is hard, Mom. But today, we changed things. Not just for one family, but for hundreds." 2 weeks later, Tanya stood before a group of law students at Howard University, where she had once studied. They had invited her to speak about the landmark case that was now being discussed in housing law classes across the country. "The law is powerful," she told the eager faces before her, "but only when someone is willing to wield it on behalf of those who need it most." A student raised her hand. "Ms. Washington, how did you feel when the judge laughed at you that first day?" Tanya smiled, remembering the moment that now seemed so long ago. "I felt what many of you will feel in your careers, underestimated. But I also knew something he didn't know yet, that I was thoroughly prepared, that I understood the law, and that justice was on my side." She looked out at the diverse faces watching her. When someone underestimates you, don't get angry. Get strategic. Let your knowledge and preparation be your response. The sweetest victory isn't proving someone wrong, it's proving yourself right. As Tanya finished speaking, the room erupted in applause. In the back row, unnoticed by the others, sat Judge Robert Harrington, nodding in silent agreement.